Welcome back to Good Law, Bad Law. Well, you thought that the confirmation of Justice Kavanaugh was contentious. Wait till you hear the story about the confirmation battle over Justice Abe Fortas during the end of the presidency of Lyndon Johnson in 1968. And this isn't just a story out of history. This is a story that really defines all of the confirmation battles for the Supreme Court that have followed since 1968, and really the battle over the direction of the Supreme Court itself. It's a story really well told by author Michael Bobelian in his new book, Battle for the Marble Palace. The Marble Palace, of course, is the Supreme Court itself. And we have a fascinating conversation about the history of the civil rights movement, which is involved, the undoing of the separate is equal ruling by the Supreme Court in 1896 through the Brown versus Board of Education decision, and all of what that has done and what that has led to all the way up to the present time and beyond. It's a great conversation with Michael and his new book. You're going to really enjoy this episode. Stay tuned. Welcome back to Good Law, Bad Law. On today's episode, my guest is Michael Bobelian. He's the author of a brand new book on the Supreme Court and a fascinating story that really sets the stage and helps us understand better what's going on with the Supreme Court today, in particular with the now routine controversial nomination process for confirming Supreme Court justices. So my guest, Michael Bobelian, the author of Battle for the Marble Palace, Abe Fortas, Earl Warren, Lyndon Johnson, Richard Nixon, and the Forging of the Modern Supreme Court. Michael, thank you so much for being on the program.
Thank you. It's a pleasure to be here.
Michael, this is a story that I am so interested in, and I think most people are and should be, because we now pay such close attention and see the drama as new Supreme Court justices are nominated and then go through what has become sort of a routine, grueling confirmation process in the Senate. But you take us back to a time not that long ago, actually, much closer to modern times than probably most people realize, to give us some really important context for understanding current Supreme Court confirmation battles, and truly a gripping story with larger than life figures like LBJ and Nixon and former Chief Justice Earl Warren. And so give us a little background, Michael, on yourself. I know that you are a contributing writer for Forbes.com, but give us a little background on yourself and how you came to be interested in this story, because I think that's a story within the story that is also very, very interesting.
You're absolutely right. I'm a lawyer, and I practiced law at a big firm in New York City for a few years, and I switched to a career in journalism and writing, and I've still been fascinated with the law. I've been writing about it since 2003, and what happened was, I've covered the Supreme Court in terms of the contemporary Supreme Court, but I was looking at a website. It's actually still up. It's on the U.S. Senate's website, and it had a list of all the Supreme Court nominations dating back to George Washington. And if you look at most of the 20th century, the nominees are confirmed very swiftly, within weeks, sometimes days, sometimes within a day, rather than months. And they have the vote count, and a lot of times, instead of a vote, let's say 70 to 2 or 90 to 3, whatever it is, it just said V. And I'm thinking, what's the V stand for? So I scroll down, right? You're a lawyer, so you go to the footnotes all the time, right?
Right.
And V stood for voice vote, which is where the Senate acts expeditiously and often unanimously, where senators just say yay or nay in unison. I said, wow, that seems very cavalier. So I looked deeper, and I saw that the grueling process that we know of today wasn't the case at all. Hearings were very pro forma. Some of them lasted just a few minutes. They were often doled out to a subcommittee rather than the Senate Judiciary Committee. There were no background checks, ideological litmus tests, and the Senate kind of rubber-stamped most confirmations. Between 1894 and 1967, only one person was rejected, and as I said, most people were confirmed rather easily and handily. So I wanted to see, well, how did we get to where we are today?
Mm-hmm.
And having gone to law school in the 90s, I was under the conventional wisdom that it was the Robert Bork nomination in 1987 that kind of upended the confirmation process. But when I looked deeper, I saw that it was actually a different confirmation fight in 1968 involving Abe Fortas that, to me, is really the changing moment in how confirmations played out. And that event, as well as what followed soon thereafter during the Nixon administration, really created the template of the confirmation battles we have to this day.
Well, and we're going to get into that story with Justice Fortas in 1968. And I know that part of the story is of course, the personalities involved, but also what was really going on with the Supreme Court and what was going on more broadly in our country at that time in the late 60s that created a completely different focus on Supreme Court nominees than all those decades before that you saw on that list in the Senate website. But you mentioned Robert Bork, and I know that story very well. I was a journalist in Washington in the 1980s and covered the Robert Bork nomination. He was nominated by Ronald Reagan and ultimately was defeated. His nomination was defeated in the Senate after a really contentious confirmation proceeding in the Senate. And we now have this term as a result of what happened to Justice Bork. We talk of a Supreme Court justice being borked.
That's right.
Right. But your story takes us back, 20 years before that. So I think you have to tell us a little bit about who the key players were and what was going on with this. And this, I know you have to read the whole book to get the full story, and I do encourage people to do that because, as I say, it's really well done. I've really enjoyed reading the book myself. But so maybe it's a little unfair to ask you such a very broad question, but give us a little of the background as to what was going on in the 1960s that created an environment where the nomination of Abe Fortas to become Chief Justice became such a contentious moment in our country's political history. Right.
Well, Aaron, this is like a good law school question. I got to summarize a lot of stuff very quickly.
Right. Yeah.
So obviously it was a very divisive time, right? Much like we have these days, different issues, but a very divisive time. And the court did contributed to that divisiveness and got caught up in it as well. So you have a much more politicized era in the late 60s than, let's say, you had in the 40s and 50s. So that's one sort of big picture issue. But in terms of the specific players, you have Lyndon Johnson, who is in his last month in office. He nominates Abe Fortas in June of 1968. Fortas had already been an associate justice, confirmed very easily just 3 years earlier in 2 weeks through a voice vote, as I had said, like many other nominees of that era. And now he wants to promote him to become Chief Justice and replace Earl Warren. Now, Johnson was sort of the first president to really look at the court through the ideological lens that modern presidents do. Certainly his predecessors looked at a nominee's ideology, but not the way we do now. They didn't, now we have this granular measurement of how conservative or liberal someone is based on very specific issues and how often they agree with this other justice or that other justice. None of those assessments existed 50 years ago. But Johnson was sort of the first president to really see the court as another way to promote public policy that you couldn't get through the elected branches in the federal and state governments. And he wanted justices who would continue to perpetuate the liberal legacy of the Warren Court, and he wanted justices who could protect his legislative accomplishments, right? Just as Obamacare was tested in the courts, he knew that his Great Society programs from Medicare to the Clean Water Act and the 1964 Civil Rights Act and so on would be tested in the courts, and he wanted that legislation to be shielded from scrutiny. So those were his motivations for how he selected justices. So you have Lyndon Johnson there. Abe Fortas happened to be a close friend, one of his closest advisors, and you'd figure, okay, Fortas was this brilliant lawyer. Of course he must have advised him on legal issues, and he did. But he also advised him on the Vietnam War and riots in Detroit, on all matters of legislation. He would help write speeches for him. He was the one who came up with the idea for the Warren Commission to investigate the JFK assassination. So he's very close to Warren, Johnson is, and he knows that Fortas is this brilliant lawyer and a liberal lawyer who will safeguard his legacy, and so he wants to nominate Fortas to become the new Chief Justice. And then you have the opposition, which some of the leading players on the opposition, and these are in the Senate, so it's a little bit more fragmented, but you have Strom Thurmond, who by then is the Republican kingmaker in the South. You have Robert Griffin, who's not a person that's well known now, but he was a Republican freshman out of Michigan, and he wasn't particularly ideologically conservative, but he was more of an institutionalist. He wanted the Senate to play a much bigger role in the confirmation process. He didn't really have a lot of problems with Fortas versus Thurmond, who did. Thurmond despised the Warren Court, and he saw Fortas as Warren's ideological heir. Griffin, on the other hand, said, you know what? The Senate's been rubber stamping these nominees for decades now, and it should play a much bigger role. So you have Griffin kind of taking a more partisan and institutionalist opposition, and you have Thurmond with a much more ideological opposition. And then you have the Southern Democrats who, like Thurmond, despise the Warren Court, and they had spent 15 years trying to neutralize the Warren Court in various ways, and we can get into that later. And they had failed, basically, and they saw the selection of justices as the best way of controlling the court. And all of a sudden, they now focus all of their energy that they had kind of done in different ways, directed at the Warren Court, towards the selection of Earl Warren's replacement. And that's how the confirmation process really just blows up and goes into this revolutionary change.
Well, let me pick up on a couple of things, because one thing I noticed just in listening to what you've shared so far is really what happens when you start to take on this story, and in the way you write about this and have to tell the story, which is that you start at a certain point in time, 1968, with LBJ, but then you have to go back in time to an earlier point and explain that to make sense of what happens at 68. Then you have to go further back in time, and it is why the history is so crucial here. So, I mean, you mentioned Strom Thurmond and LBJ really starting to look at the role of the Supreme Court justice nomination process differently than presidents had looked at that previously. But to understand how he so acutely picked up on that, you have to see how the court itself changed, right? And Strom Thurmond actually starts out as a Democrat, like many of the Democrats in the southern states. But when Earl Warren joins the court, and this is history I'm familiar with, but you tell it, in a narrative way that is so, makes it almost sound like a thriller, and it is that. Earl Warren joins the court right as the Supreme Court is taking on Brown v. Board of Education. And all those Southern Democrats, when the Supreme Court announces its decision on school desegregation in Brown, they all shift and become Republican. And now you've got this deadlock in Congress in terms of trying to get through civil rights legislation, even though LBJ, pretty brilliantly was able to accomplish as much as he did with voting rights and other major pieces of civil rights legislation. And so people like Thurgood Marshall, a future Supreme Court justice, but at the time of Brown in 1953, the one arguing on behalf of the NAACP for desegregation, he turns to the court because he realizes, as you explained it, he realizes that we're not going to get change through the Congress, which now has shifted so dramatically in its politics, and the court takes on that role in a way that it hadn't quite so dramatically before. So tell us about the impact of Earl Warren and the Brown decision and how that becomes so important in the role that the Supreme Court takes on.
That's right. That's a great question. Thurgood Marshall and the NAACP tried for decades through the political process, through Congress, to try to end Jim Crow in the South, which was essentially an apartheid state. And they couldn't even get an anti-lynching bill through Congress. And they tried dozens of times, more than 100 times actually. And the handful that made it past the House were ultimately filibustered in the Senate. Even when FDR was president, he couldn't get the Southern Democrats to go along with an anti-lynching bill. So Thurgood Marshall realizes, wait a minute, we've tried the political process, it's not working, let's go through the legal system. And in the late 30s and throughout the 1940s, there are these small victories that are kind of chipping away at segregation and the legal foundation of segregation. And then Brown v. Board finally does away with it completely. And it's revolutionary in a couple of ways because it basically enforced the 14th Amendment in a way that Congress was supposed to and hadn't. So in a way, the court was filling this role that the political branches continually were failing to do. And that's a big theme throughout Warren's tenure. But Brown v. Board was more than about ending segregation. It kind of set the tone that the Warren court would be an activist court, but a lot of people falsely assumed that, oh, yes, they were just liberals and they wanted to get their way. That's too much of an oversimplification. A lot of what the Warren court was doing was solving problems that were better suited for the political branches, but that the political branches were simply either unwilling or incapable of tending to. And another example of that is the reapportionment rulings, the one-person, one-vote rulings of the 1960s. The legislative districts had become so malapportioned where a small town would have the same number of representatives in a state government as a big city, or Los Angeles with millions of people would have the same number of representatives as a county with 100,000 people. So there were really malapportioned legislative districts on the state and federal level throughout the country. And by law, the states were supposed to rejigger their districts every 10 or so years, and many of them had not done it for decades, and it really was hurting urban and suburban populations, and rural populations were overrepresented by 50%, 100%, 500% at times. And again, best suited for the political branches to solve that problem, but the voters who had been deprived of their representation in government, they ultimately went to the court, and the Warren court kind of gave them the solution that they were incapable of getting through the political process. So that's really, to me, the Warren court's revolution is tackling a lot of matters that the political branches have failed to deal with on their own. Brown v. Board is the ultimate example of that because the South kept saying, well, no, we're dealing with race relations, we're doing better, let us work at our own pace. And the Warren court said, wait a minute, you've had, since the Civil War to deal with these issues, and you've largely failed, so we're going to step in. And I would argue that until LBJ becomes president and Congress in the mid-60s really starts to enact all of this liberal legislation, that Earl Warren is in many ways the leader of American liberalism in that decade where he's in office, like I said, until LBJ and the Congress of the mid-60s.
Yeah, it's so fascinating because we have really bought into this idea even much more so in the modern political times we're in. This idea that there are liberals and there are conservatives, and by applying those labels, it's as if we all understand what that means, you know. But as you continue to back up in history so that we can then move forward again and understand the times we're in 1968, and of course the not so subtle import of this history from 1968 is to better understand Justice Kavanaugh and Justice Gorsuch and Merrick Garland, you know, the current times that we're in, of course. But, you know, this idea of Warren as a liberal justice, or the Warren court as a liberal court, and I'm not sure I've ever really thought of it this way until just now listening to you, but, you know, the Civil War was a fight in large part to end slavery, which was, as you say, the original sin, you know, dating back to the founding of the country, that we have these lofty goals and visions expressed in our founding documents. But of course, we had slavery. And then you fight the Civil War to end slavery. The South is defeated. Slavery is ended by the 13th Amendment to the Constitution. Then the 14th Amendment, you know, establishing what really should have been established, but now applying to the states, due process and equal protection. And the 15th Amendment granting the right to vote to former slaves. But then you have, through the rest of the 19th century, as you say, the legalization of segregation, culminating in the Supreme Court's Plessy versus Ferguson separate is equal decision in 1896. So we talk about Warren and Brown versus Board of Education, which of course reversed Plessy and said separate is not equal, as being liberal. But I mean, is that really liberalism to say that, you know, that we're going to undo the legal framework for the very practices that we fought the Civil War over, you know, and that the founding documents professed to be at the core of what our country is about? I mean, if that's liberal, I mean, why aren't all of us liberal?
Right. Well, the labels were different then, and Warren was a Republican, and the Republican Party was the party of civil rights, pretty much heading into the 1940s and 50s, and in fact, in the 1956 presidential election, in the GOP's platform, right? The parties put out a platform every 4 years during the presidential election. The party wanted to take a lot of credit for Brown. They saw it as something that they should be proud of, since Earl Warren was Republican, and they were the party of. They still thought of themselves as the party of Lincoln. So Republicans were more conservative than Democrats, but at the same time, when it came to civil rights, some Republicans, at least, were more liberal than some Democrats. So the labels then were very different, and I agree with you that shouldn't be liberal or conservative. That should just be an obvious ruling. In hindsight, it's like, well, what took so long? What took the country and the court so long to get to Brown? Why wasn't this done much earlier? Why did we have the Civil War? Why did we have the Civil War amendments to the Constitution afterwards? Why had this situation, why had it gone on for so long? So I agree with you that the label doesn't really make sense when we look at it from today's definition.
And it did. It changed at that time. You're right. I mean, liberals were Republicans. Lincoln was a Republican. Earl Warren was a Republican. And it seems like it was the reaction to the undoing of Jim Crow, the undoing of segregation, at least. Not that there wasn't a lot of work to do after Brown, and still a lot of work to do even today, but through the Brown versus Board of Education case, that seemed to be the fulcrum point, or the focal point of this shift in what liberal even meant, what liberal and conservative even meant at that point.
In some ways, I would say in the South, it's you take Brown and then you take the civil rights bills of the mid-'60s, and that flips the South from being primarily Democrat, almost where the one party monopolized political life there, to primarily being Republican now. But there were other decisions that the Warren Court made that offended people who we now call conservatives. And they were in both parties then, and now, the parties now are much more ideologically purified. So it wasn't, so you had Democrats who were conservative and Republicans who were conservative back in the 60s. And one of those rulings, I already mentioned the reapportionment rulings with the one person, one vote, but it was the ban on school prayer. In the 60s, the court said you can't have prayer in public schools. And that ended up being the most unpopular ruling of the Warren Court. And about 80% of the American public disapproved of the ruling. And so you had religious conservatives now, who were, as I said, they were Democrats and Republicans, now seeing the court as a target. Then you have the criminal procedure rulings, like Miranda is the most widely known one, and that offends a lot of people who are now consider themselves conservatives. And you had issues of obscenity. Back then, adult magazines, adult movies were sort of the big culture war issue of the day, and the court had a really hard time trying to balance the First Amendment rights of the content producers versus the rights of communities to be able to limit this kind of material from their communities. So all of these things offend different segments of American society. Ultimately, those segments coalesce to what we now call conservatives, and most conservatives today are in the Republican Party, but they were kind of in both parties at the time, and you're starting to see this shift in the 60s of the parties becoming, Democrats becoming more liberal and Republicans becoming more conservative, and the court played a role in that, and it's sort of like an additive, let's say, if you're doing an experiment, and it's an additive that's instigating that process and accelerating that process, but at the same time being impacted by that process.
And another interesting feature of some of these rulings that you're describing during the Warren Court years, the 1950s and into the 1960s, is another point that kind of harkens back to the Civil War times, which is that this idea that no, it's not going to be okay for certain parts of the country to have some certain rules that are so diametrically opposed to rules that apply in other states. We're not going to have a culture or a practice of segregation in the South because that's okay in the South. We're going to have rights that are fundamental, and they will be declared by the Supreme Court and will apply to all citizens, no matter where you are in the country. And that seems to be something that also really rocks the politics of that time and focuses on the role of a Supreme Court justice in a way that it really hadn't before. That's
right. Warren had two foundational principles that he really pushed. First, he wanted the country to try to live up to the lofty ideals of the Constitution and the Declaration of Independence. And in many ways, obviously, segregation in the South is probably the primary example, but in many other ways, the country was not living up to those ideals. So he tried to push the country closer to that. It's not something previous justices had really thought that that's their goal or that's their mission or that's their role in the political process, but he did. And then the other thing he was willing to do was use the court as an agent for that change. So you have Felix Frankfurter, who was a New Deal Democrat, but who ended up being the sort of the conservative rival of Warren on the court, and he kept saying, no, the justices should stay out of the political process. You should give a lot of freedom to the political branches. And Warren, in return, would respond, no, we have these lofty ideals. The political branches continue to fail us, and I'm going to use the court as a means to get us closer to that ideal. So you have this really big tension, which now politically we say breaks down the conservative and liberal lines, but at the time it was much more of a judicial philosophy, because theoretically Frankfurter was as liberal, if not more so, than Warren.
In his politics.
His vision of what a justice should do was very different.
Yeah. Well, and this idea that the Frankfurter vision of deferring to the political branches to make policy, maybe a predecessor of what we now call originalism, which is looking to the text and not getting involved in things that become very political, which is really what President Reagan started to do. I mean, he also recognized the importance of the Supreme Court, but as a way of shifting to more conservative principles through his Supreme Court picks. But bring us back to LBJ and Johnson, LBJ and Abe Fortas. How do all of these forces that we've now described a bit come together to bring down Justice Fortas?
Right. So as I said, the Strom Thurmond, all these opponents and rivals of the Warren Court spent 15 years trying to neutralize the court. There were thousands of speeches condemning Warren for Brown, as well as all these other rulings, the criminal procedure rulings, the reapportionment rulings, and so on. They try to pass legislation stripping the court of its jurisdiction. They try to enact constitutional amendments to overturn the reapportionment and school ban, prayer ban rulings. And these are very high thresholds to meet, right? Because the court had enough support in Congress to stop these efforts. So by the late 60s, Strom Thurmond and other opponents of the court realized, you know what? All of these things we did the last 15 years to resist the court, to undermine the court, to neutralize the Warren Court, ultimately fell short because they're just too difficult to do. And they said, we're going to now focus on the selection of justices. Now, so that's the realization they kind of come to by the late 60s, but they also have the political opportunity because Johnson in March of 1968 announces that he's not going to run for re-election. In June, he nominates Abe Fortas. He has lost a lot of his political capital by then because he's not going to run for re-election.
He's a lame duck.
A lot of Senate liberals no longer support him because of the Vietnam War. So he's in a very weakened state. And Thurmond and his allies realize, wait a minute, we now have the potential political opportunity to actually win this battle, to win this confirmation. So that's how the battle kind of begins. That's how all these forces kind of come together. And they didn't. And Abe Fortas was their target, but not because of who he was or what he was doing. It's because of what he represented. He was Johnson's protege, and he was Earl Warren's ideological heir, his heir to the throne, if you will. And it's because of that. He's kind of the target because of what other people stood for and had done, rather than what he himself had done. He was not seen to be some reprehensible person. He was seen as like I said, the symbol for what others had done. And because LBJ was leaving office and Earl Warren was untouchable as Chief Justice, Thurmond and his allies say, you know what, we're going to go after the next best thing, and that's Fortas, and we're going to torpedo his coronation here.
And they did, right? They were ultimately successful, even though, I mean, there really wasn't any dirt, like you said, there wasn't any dirt on Fortas. It wasn't like he was unqualified or was thought to be anything other than a brilliant lawyer and was already on the court, as you mentioned. So how did that play out? How were they able to defeat him? Because before, presidents, as you say, nominated justices. It didn't result in a lot of heat in the Senate. They just kind of it was almost like they could reward somebody like they liked with a pick, rather than it becoming so important in how in the direction the Supreme Court was going to take. How did that actually go down ultimately?
Right. So they shattered all the norms and traditions that govern the confirmation process, and they used a lot of tactics that have now reappeared in recent times. And I'm going to give you a couple of examples. So in 2016, President Obama nominates Merrick Garland, and what does Mitch McConnell and the Senate Republicans say? They say, well, he's a lame duck as president. We should let the next president fill that Justice Scalia's vacancy. That seemed something out of the blue, but that was the first argument made against Fortas in '68. People said, wait a minute, Johnson's a lame duck. He's going to be out of office in about 6 months. We should have the next president select Warren's successor. So that was one argument they made to kind of slow down a quick confirmation. Then they said, well, Fortas and Johnson are very close. Fortas is his crony. He's being rewarded for being a presidential advisor and a friend to the president. And they brought out all this information about and how much work Fortas had done for Johnson, even while he was an associate justice. He was in cabinet meetings, he was helping write speeches, and so on. But here's the thing. That had been done since the Washington administration, in the 1790s. So presidents and justices were close. Harry Truman was close to Chief Justice Frank Vinson. FDR was close to William Douglas. They used to play poker together. He nearly made Douglas his vice president. So that had been a common practice, but now all of a sudden it was being used against Fortas. Similar to, it reminded me of what happened to Zoe Baird, Bill Clinton's first Attorney General nominee. Right, we had the whole Nannygate issue, and that was something where pretty much everyone in Washington operated the same way. But now all of a sudden, this indiscretion could be used as a kind of like a scandal to destroy someone's political aspirations. So you have those two issues come up, and then we have a filibuster. So in 2017, Senate Democrats tried to filibuster Neil Gorsuch. Well, conservatives did filibuster Abe Fortas, and ultimately he wasn't able to prevail to get enough votes to succumb to the filibuster. So those are kind of the three tactics that they used that we saw replayed in recent times. And then they used some very unorthodox methods, and I'll describe one because it's kind of a dark comedy, if you will. As I said earlier, the obscenity was a big culture war issue of the day, and the court had a real hard time balancing the First Amendment rights of how to deal with the proliferation of adult materials that occurred in the 60s. And so Strom Thurmond took advantage of that. He had witnesses come in and testify that the court was the chief inspiration for the smut that was proliferating in the country and that led to the moral decay of the country. And he started to air some pornographic films in the Senate, and they didn't have a theater room. The Judiciary Committee didn't want him to do it, but he did it anyway. The first movie that they aired, he had a coin-operated projector. There wasn't even a screen, so he broadcast it on a wood-paneled wall. And then it became sort of this long-running gag. They watched dozens of movies in the Senate over about a month and a half period, and it'd be a joke like, oh, Thursday night, it's going to be a twin billing, come watch. And 20 senators would show up, or 15 senators would show up, and they came to call it the Fortas Film Festival. And Fortas was called Mr. Obscenity at the end of it. And that really hurt his nomination in terms of the public. You see the hate mail sent to the Senate in the National Archives really mushrooming during the Fortas Film Festival. So that's a very unorthodox tactic, if you will, even by today's standards. Yeah. And so all these new methods were used to torpedo Fortas, and as I said, ultimately they succeeded.
So, and you mentioned too that when Nixon becomes president in '68, he sort of be careful what you ask for. They brought down LBJ's nomination, and then Nixon also experiences some of the same fate in terms of his Supreme Court nominations. What's the connection there, do you think?
Right, and that's really a key point to my understanding of that era is, had the Fortas nomination fight just been a one-time blip, and we'd gone back to a confirmation process that resembles what we had beforehand, right? This kind of casual process, the Senate would rubber stamp nominees, then I would say this would have been a dramatic moment in history that didn't really have a long-term impact. But what happens over the next 2 years kind of reaffirms how important the 68 battle was. So the first thing that happens is about 6-7 months after Fortas is defeated in the filibuster, he is pressured to resign under scandal, and he's the only justice to ever resign under a cloud of scandal. So that happens in May of 1969. We're in the 50th anniversary of that, basically. And then two of Nixon's nominees to replace him, two Southern judges named Clement Haysworth and G. Harold Carswell, are rejected by the Senate in quick succession. And again, some of these unorthodox and unprecedented tactics that were used against Fortas are now deployed against Nixon's nominees. So you go from a situation where only one nominee had been rejected for over a span of about 70 years, and now you're getting three nominees in quick succession. You're getting a justice to resign under scandal. Then Nixon ups the ante even more. He says, oh, you know what? You rejected my two guys. I'm going to get my revenge. And he tries to impeach William Douglas, who had been one of the liberal titans of the Warren Court. And no justice had been impeached since 1804. And they go through a 6-month impeachment proceeding in the House, and ultimately he's exonerated. But you're thinking to yourself, wait a minute. You have three rejections using, as I said, unprecedented tactics. One justice resigns under scandal. Another one is nearly impeached. All of this happens in about the 2.5, 3-year period. And that, to me, is what sets the template for the modern confirmation fights we have to this day. So the Nixon nominees coming in such quick succession to what happened to Fortas really kind of cements what happened in 1968 into the political fabric of the country and kind of makes it a permanent situation rather than a one-off situation where, Fortas just happened to be this, random victim of circumstances. No, instead, he becomes the first person to kind of go through this rigorous process.
Well, and it'd be easy, I guess, to say this just sounds like the politicization of the Supreme Court confirmation process, and you could look forward from 1968 and say LBJ was a victim to this, then Nixon was a victim to this. You mentioned Clinton's nomination was a victim to political attack on his nominee, and Obama with Merrick Garland, and even the not so much Gorsuch, I guess, but certainly Kavanaugh. On one in one sense, his confirmation was all about these sexual assault allegations, but it does seem like what underlies all of this is a battle over the direction of the Supreme Court itself, and not even so much the fate of one justice or another, but a real battle for presidents and supporters in Congress trying to exert control over the direction of the Supreme Court itself.
Absolutely, and that that happened before FDR's court packing plan in 1937. Right, he's trying to exert control, but what changed was now this became, instead of a one-off thing that FDR tried, this now became a permanent theater of political warfare, and that's really what changes in the late 60s. That it's not so much that we had, the justices were all platonic guardians and they were never politicized and they never had a ideological agenda. No, they did. It's just what happens is that it's taken to a new level, and now it becomes a permanent battle. And the main reason for that is, in a way, the accomplishments of the Warren Court showed both the left and right what the judiciary, and particularly the Supreme Court, is capable of doing. An NAACP example is the best personifies that, right? As we said, Thurgood Marshall and the NAACP tried to go through the political process, and they hit a brick wall time and again, and they succeed through the courts. All these other groups that couldn't find any recourse through Congress or state government on things that were very obviously unjust find their recourse through the courts. Now liberals see that and they say, oh, wait a minute, why don't we perpetuate this, which was LBJ's thinking. But conservatives also see that and say, hey, wait a minute, let's first put a stop to this, which is sort of what Nixon is trying to do. And then by the time you get to Reagan and Bush and now Trump, where there are more conservatives on the court, now they say, well, wait a minute, now why don't we do what the Warren Court did, but for conservative ends, right? And you get Citizens United and a lot of more recent rulings in the last decade or two that liberals abhor. But they're really using the same playbook that was used in the 50s and 60s. I would say the difference was that Warren and the other liberals on the court didn't see it as, they didn't pre-plan this. They didn't see it as like, well, I was put on the court to push a liberal agenda. It was much more ad hoc. It was much more really case-by-case basis. There happened to be liberal rulings, and in how we measure them now, but they didn't go in such a calculating way. Whereas now, I think the justices and certainly the people who put them on the court are very calculating in terms of, yes, I want this person here because he's going to promote X, Y, Z, or I want this person here because she's going to promote these other policies. So what's happened is the kind of what played out in the 50s and 60s and the accomplishments of that court showed future generations, wow, look how much you can accomplish through the Supreme Court, and now people are just more calculating about it. So what started then is now being perfected. It's almost like a scientific process that's being perfected, and unfortunately it has led to much more of ideologically extreme justices. I believe 9 out of the 10 most conservative justices in the Supreme Court's history have been appointed in the last 4 or 5 decades. And the same thing is, almost all 8 out of 10 or 9 out of the 10 most liberal justices have been appointed in the last 50, 60 years. So you're getting fewer centrists, which I feel like the court needs, and you're getting a lot more people who are either very liberal or very conservative because they're taking the model of that era and, as I said, perfecting it and taking it to its extreme end.
Well, also, I wonder, again, coming back to something we were talking about earlier, the notions of what liberal means and what conservative means has changed a lot in the last 50 years, right? I mean, we did an episode of the podcast a couple of months ago about the role of the Supreme Court in using the 14th Amendment far more to decide cases involving the rights of corporations,
right,
than to use the 14th Amendment the way really it was designed, the purposes it was designed to serve, which were individual rights. And the Supreme Court didn't wade into issues of privacy and obscenity and desegregation and same-sex marriage and in the 50 or 100 years before the way it does now. And so or religion, issues involving the tension between speech and religious liberty. So now those issues are more individually focused, and those are the issues that have come to define liberalism and conservatism.
That's right. And if you look at sort of the culture war issues of the early 20th century, Monkey Scopes trial, right, women's suffrage, the court really kind of keeps its hands off of those issues. As you said, it focused a lot more on economic regulation, and that ultimately came to an end at the end of the New Deal. But the Warren Court, its primary focus becomes these issues of individual liberty, individual equality, and individual rights. And it comes up with a lot of liberal rulings, but then conservatives say, well, you care about gay marriage, we care about gun rights, right? That's also in the Constitution. So now both sides are focusing on these issues of, like I said, that are focused on the individual, but they're trying to push the rights that matter most to them and kind of limit the rights that don't seem as relevant to them.
Well, and I wonder too, and some of this you could, I think, hear and say, "Oh my God, we've just completely ruined the Supreme Court. It's all about politics now and who's in power and who's not." But you make a great point about those who have turned to the courts to press rights that are important to them and that they find in the Constitution, in the Second Amendment, let's say, or those who are pressing for religious liberty that they see in the language of the First Amendment. I mean, I wonder, we can agree and disagree about what that language means and what rights that the language of the First Amendment or the Second Amendment allow, or what the limitations on those rights ought to be. But I wonder, isn't that a good conversation to be having? If we could have that conversation, Right. We have a Constitution. It lives and breathes in the year 2019, and we do see in it what we want to see in it, And then we have to debate about that. We have to argue about that. I wonder, isn't that a good thing?
I think those are very valid debates. I would say in terms of the court's involvement, I would hope, ideally, that the political process would come to a widespread consensus on a lot of these issues. And I think that's where a lot of modern advocacy is not taking up the NAACP's original model of try to go through the political process. I think a lot of modern advocacy says, well, why are we going to go state by state or congressman by congressman and try to change people's minds? If we just get 5 justices to agree with us, we can get our way through that process. And that's why you have the Supreme Court issuing these rulings, but in terms of the public or political consensus, there's often not one. And I wish the political process worked better, worked more effectively, and the court would allow the political process to play out a little bit longer before it stepped in. Now, you could say, but if there's an injustice, you should stop it. I agree. Brown v. Board, the courts waited too long to stop that injustice.
Right.
But at the same time, a lot of these newer issues that are coming up that are only years or a decade or two old, you wonder, is it better to let the political process develop a consensus, and then maybe when then there's a decision, many more people in society will accept it rather than, these 5 justices ruled, for or against abortion, and if we just get our 5th person in there, we'll just overturn it, right? And that seems like, whoa, wait a minute. Do we want a country of 320 million people, spread from 7 time zones, if you go all the way out to Hawaii, right? Do we want 9 people who are not democratically elected making such decisions? Wouldn't it be better to get a consensus for it rather than having 9 people decide it? So that to me is the danger of having the court play not so much a prominent role, but get into these debates a little too quickly. I wish it would defer and let these debates play out in the political branches a little longer before it steps in. Now, that being said, the political branches in many ways, especially Congress, I feel has abdicated its duty.
Yeah. Right. I think that's a great point. And, I guess the one example I can think of that runs against that, because, there's so many issues you can think of and say, well, why doesn't Congress just take this up and they are lawmakers, let them make a law rather than letting it end up having to be decided by the court. But I guess the one example that I can think of that runs against that is abortion. And now we have states moving to some pretty what are, I won't say radical in a political sense, but dramatic limitations on abortion. Alabama, as we record this, Alabama just passed, maybe one of the most restrictive abortion laws at the state level, clearly knowing that those issues are going to percolate up to the Supreme Court. And so there at least is one example where you can, whatever your view is on that, and we're a country very divided on that issue, obviously, but you do have a political process that's playing out not just in the South, but states like Ohio have also passed similar laws, and it is going to get decided somewhere or another by the highest court.
Yes, and some things are unavoidable, but some of the simpler things can be done very easily, and I'll give you two examples. In the white collar crime setting, insider trading is largely been decided by a combination of court rulings and SEC enforcement actions and Department of Justice enforcement actions. Congress could easily step in and write the law on what constitutes insider trading and save people years and decades of litigation and save the courts a lot of headaches. But it has not been willing to do so. Last year there was a case involving how sales tax should be applied to online commerce, right? To e-commerce. Now, during the oral arguments, the justices practically begged Congress to step in and just tackle the issue. This is something, Congress is supposed to oversee interstate commerce. This is something that Congress should be doing, and it has not updated the law since the 1990s, and it's forcing the court to do it. A lot of the environmental lawsuits that end up in front of the Supreme Court are because the environmental regulators are trying to use laws passed in the 60s and 70s when our environmental concerns were very different, and trying to apply those laws to modern-day concerns about climate change or whatever, a new pollution is that we didn't have, a new pollutant that we didn't have 50 years ago. And again, if Congress stepped in and simply updated some of these laws, you wouldn't have to have the courts involved. It would be much more efficient. It would be much more reflective of the majority's will. And these aren't constitutional issues that we need the court to decide. So a lot of times Congress is simply not fulfilling its duty as a lawmaker. And it's forcing the court to do it, but it's also politicizing the court on issues that don't need to be politicized even, because they're really regulatory issues or lawmaking issues and not constitutional issues. So I get that the constitutional issues, the court's going to get involved, and there's almost no way around its politicization. But a lot of these statutory issues, Congress should really be taking care of on its own, but it has failed time and again in the last 10, 20 years to do so. And that allows the court to play this role that really should be played by the legislature, but it also politicizes the court even more than it already is. And so I think some of the fixes are more straightforward, and some of it, as you said, like with abortion, there's no way around that. It's going to end up in front of 9 people, and they're going to decide. But at least the things we can fix, and from a very straightforward way, and from a way that's not even ideological, it's simply, what is the best way of running a national economy? Should we have sales taxes for e-commerce, and what should be the basis of that? Just that's something that compromise and the basic legislative process should tackle pretty easily.
Well, it does seem too that more and more, as I guess you could say, the Senate, which has the responsibility to confirm the president's nominations to the Supreme Court, as the Senate has awoke, maybe starting in 1968, as you lay out the story in the background to that, it's not going to go back to sleep on that issue. The party that controls the Senate, or the political philosophy or ideology that controls the Senate, is going to continue to have control over the direction, because they are going to assert a kind of scrutiny on Supreme Court nominations with ideology in mind. It just doesn't seem like we're going to be able to put that back in the bottle.
No, and I don't have a problem with that. I think what Robert Griffin said in '68, he has this line where he says, the president only has half the power. We have the other half, and we as the Senate, and we should start using that power. And I think the Senate having a bigger role is a good thing, because a cabinet appointment is very different than a Supreme Court appointment. A cabinet official is part of the executive branch. He or she works for the president, right? And I think there the Senate should be more deferential. But a Supreme Court appointment is not part of the executive branch. He or she does not work for the president and is there far longer than the president's tenure. I think greater scrutiny is called for. But I would hope, and really the 2016 Scalia replacement would have been an ideal time for this, where you have a Democratic president with a Republican Senate, and that would have been the ideal time to come up with a compromise candidate, to say, okay, Democrats want someone very liberal, obviously Republicans want someone very conservative. Why don't we pick a centrist judge? Why don't we pick someone who's center-left or center-right, so that neither of us are maximizing our position, are maximizing the political opportunity here, and instead we come up with someone who all of us can not maybe be happy with, but all of us can live with. And the fact that that didn't happen is disappointing, because that would have been an ideal situation to really, I think, use the Senate's scrutiny, which, as I said, is called for and is justified, but at the same time, not use it in a way where both political parties are just trying to maximize their advantage, but instead use it in a way where the president and the Senate work in cohesion and come up with a compromise pick. And frankly, the court could probably use more centrists rather than justices who are farther and farther apart on the left and on the right.
Well, and I guess the final PS to all this is that we have a number of justices on the court now in their 70s and 80s. So we are going to see these issues playing out again, and not before all that long. So the impact of the 2020 election for president and also for members of the Senate is going to become very important. And I've always thought that people ought to pay attention when thinking about who they want to vote for president and for their senator, ought to be very conscious of the implications for the Supreme Court, and maybe the lessons of the last couple of Supreme Court battles, and with all the precedents that you describe in your book from 1968, will convince more and more people of just why that is so important. Hopefully so.
That's right. And just to turn it back quickly back to that era.
Yeah.
Presidents didn't base their candidacy on the Supreme Court. Even FDR, 1 year before he does the court packing plan, he's up for election in 36. His allies in the Democratic Party said, "Why don't we attack the court as part of the campaign?" And he said, "No, leave the court alone. I do not want to politicize it as part of my presidential campaign." That changed in the 60s. Barry Goldwater is sort of the first person to really do this in 64, but Nixon amplifies it, and he runs against the court in 68. And he's the first president to make a much more overt connection between his candidacy and the kind of people he would appoint to the court. And so, like you said, that's something that people should pay attention to. And I think it's something that presidents, especially with Reagan and Trump, have also made that a big part of their presidential campaigns. So that's another sort of similarity between that era where just as LBJ was the first one to see the court through this ideological lens, the first president, Nixon is sort of the first candidate to really see the court from an electoral perspective, from how it can, how he can use the court to reach out to certain types of voters, and then how he can appoint people to build and add to his support for re-election. So there are a lot of parallels between, again, that era and what we saw in the 2016 election and what we will likely see in the upcoming election.
Well, Michael, I want to thank you so much. This is not only fascinating, and I love history, and I love law, and I love stories about the Supreme Court. I know people will be so interested in this as well, and this is only a part of what you cover in your book. So people really do need to get the book. It's out now. You can get it on Amazon, wherever you get Barnes & Noble, wherever you get your books. Michael Bobelian, the author of Battle for the Marble Palace, a fascinating story about the confirmation battle over Justice Abe Fortas, the direction of the Supreme Court following the Earl Warren years. Great characters in the story, Lyndon Johnson and Nixon, and Earl Warren himself also. So fascinating, his personal story. And you've told a great story, and I want to thank you for that too. Please, we'll put a link to the so where people can get the book, and encourage people to do that. And Michael, again, thank you very, very much for being on Good Law, Bad Law.
Thank you. It was a pleasure.